Welcome to The Debate. Imagine a junior associate is taking notes during a highly confidential merger strategy meeting.
Okay, pretty standard stuff so far.
Right. But now imagine a cloud-based AI is silently transcribing that entire meeting in the background. It's auto-generating an action plan based on what it heard, and then, saving it as a discoverable file on a corporate server.
Yeah, if you are a managing partner listening right now, your blood pressure probably just spiked.
Seriously. And that brings us to the core of our discussion today. We are looking at a massive shift in the legal industry's infrastructure. We've moved away from the physical file rooms and the shared server drives of circa 2019 into this era of a unified digital landscape.
Exactly. And the big question we're tackling is whether making a platform like Microsoft Teams, your law firm's comprehensive, digital headquarters, is an operational superpower or, and this is where I lean, if retrofitting a general corporate platform for strict legal workflows just introduces a massive ethical liability.
Well, I take the position that Teams represents a necessary, highly secure centralization of the digital case file. And look, when it's configured correctly, it successfully fulfills a lawyer's ethical duty of technology competence.
And I take the position that relying on a generalist tool like Teams as your primary legal hub, well, it risks replacing the physical information silos of the past with incredibly complex new administrative burdens. It requires this intense security-first configuration that just fundamentally clashes with the software's plug-and-play nature.
I think we need to start at the very beginning of the legal workflow to really unpack this. Think about client intake and the immediate chaos that usually follows.
Oh, the absolute scramble.
Exactly. From my perspective, the single greatest operational threat to a modern legal practice today isn't like a hacker in a hoodie. It's the internal information silo.
Fair point.
A client calls with a crisis, right? Suddenly you've got 5 attorneys working on the matter. Within 48 hours, vital case data, strategic insights, critical attachments, they are all scattered and trapped inside individual email inboxes. Teams definitively solves this mechanical failure through its channel architecture.
But does it actually solve it? Or does it just move the chaos to a different screen? Because out of the box, Teams is essentially an open floor plan.
Well, it solves it by changing the fundamental architecture of how a firm communicates. Instead of 50 fragmented email threads where everyone is guessing who has the latest information, you create a dedicated, persistent, digital workspace for that specific matter.
Assuming everyone actually uses it correctly.
Sure, but you eliminate the endless, agonizing loop of emailing attachments back and forth. The classic draft_v4_final_v2.docx nightmare.
Yeah, I will admit no one misses that filing nightmare.
Right. By allowing real-time co-authoring directly within the interface, there is only ever one document. It is the single source of truth. And more importantly, this centralization is ethically necessary today.
You're bringing up the ABA guidelines, I assume.
I am. We have ABA Model Rule 1.1 Comment 8. It explicitly mandates that lawyers must stay abreast of the benefits and risks associated with relevant technology. In today's environment, relying on unencrypted emails or worse, consumer-grade messaging apps to discuss sensitive litigation strategy it's an ethical minefield.
I absolutely agree that consumer-grade apps are massive ethical liabilities. You will get no argument from me there. The data leakage on those is practically guaranteed.
Exactly. And Teams, operating under a Microsoft 365 business or enterprise plan, it provides the secure, encrypted tenant boundary that this ethical duty actually demands.
Sure, but I question the premise that Teams is naturally suited to replace the legal file room without an immense, precarious structural overlay. The very analysis we're discussing today comes with a massive caveat, right?
The configuration caveat.
Yes, a default setup in Teams is wildly insufficient for a law firm. If you just turn Teams on, literally any user can create a channel, invite a guest, or share a file. To lock it down, it requires strict, unyielding protocols for naming conventions, document storage, and external guest access.
Which is exactly why you configure it intentionally. You don't just use the default setup, you build it out.
But think about the implications of that for a second. If a platform is so inherently unsuited for your specific professional requirements that you have to hire third-party consultants, like the folks at MoreMax.net, for example, just to configure the software so you don't commit an ethical violation on day one?
It's an enterprise deployment. You always need experts.
But it tells me something fundamental about the architecture. It tells me that Teams is inherently a corporate chat app, being forced with immense administrative effort to perform as a specialized legal engine. And the burden of maintaining that configuration, it never goes away.
I think you are severely underestimating what that legal engine can achieve once it is properly tuned. Let's look at the integration capabilities, because this addresses your generalist critique directly.
All right, let's get into the integrations.
Teams doesn't force a firm to abandon its specialized, purpose-built legal tools. It actually acts as the centralized dashboard for them. Formal document management systems, the DMS platforms like iManage or NetDocuments or Clio, they integrate natively directly into the Teams interface.
They do plug in, yes.
So think of Teams not as a single app, but as the actual building the law firm rents. iManage or NetDocuments, those are the secure, heavy steel vaults inside that building. Teams simply controls the lobby, the hallways, and the elevators leading to those vaults.
That's a very clean analogy.
Thank you. It solves the fragmentation problem by bringing the heavy-duty tools exactly to where the daily communication is happening. You aren't forcing attorneys to constantly switch windows and lose their workflow.
It is a nice analogy, but it completely ignores the cognitive cost of that specific type of integration.
What do you mean by cognitive cost?
Well, what happens to human psychology when you nest those heavy steel vaults inside the casual lobby? In a law firm, there's a fundamental difference between an informal strategy discussion, which happens in a chat window, and the formal, discoverable, tightly controlled digital case file in iManage.
Sure, the content is different.
Right, but when you place them right next to each other in the exact same user interface, you create a kind of software inception. You are asking attorneys who are already moving at breakneck speed to constantly context switch between informal chat and formal document governance without any visual boundary to cue their behavior.
I want to push back hard on that idea of software inception. Why do you believe a visual boundary is so critical to an attorney's behavior? I mean, we transition from casual hallway conversations to formal courtroom advocacy all the time in the real world.
Because in the physical world, the environment triggers the behavioral shift. When you walk into a courtroom, the architecture literally tells your brain to be formal. You stand up straighter, you adjust your tone.
Okay, fair.
But when you open a chat interface in Teams, the UI, the emojis, the short text bubbles, the speed of replies, it tells your brain to be informal. And if that chat window is directly integrated with your formal DMS,
The attorney still knows what they're doing?
do they? A lawyer might casually drop a highly sensitive document into the chat for a quick review, completely bypassing the strict version control and the access logs of the vault. The platform actively encourages casual behavior with highly structured data.
I see your point.
I just question whether that truly centralizes work or if it just creates a precarious environment that confuses users about what is governed data and what is transient conversation.
Look, that is a fair point regarding user behavior. But the system doesn't rely on visual cues to protect the data. It relies on structural security. And that's where the Microsoft Vault concept really shines.
You mean the backend infrastructure?
Exactly. For firms handling HIPAA-regulated medical records or highly sensitive corporate M&A, the security infrastructure of the Microsoft Trust Center is unparalleled. We are talking about a company that spends billions of dollars annually on cybersecurity alone.
No one is doubting Microsoft's budget.
But it matters. Teams brings enterprise-grade protections that a standalone boutique legal software simply cannot afford to build from scratch.
Raw server security is one thing, but how does it protect against the internal risks we just outlined, the casual sharing?
Through several mechanisms. First, you get data residency. The firm can stipulate that all its data remains strictly on US-based servers, which satisfies complex jurisdictional requirements.
Standard enterprise feature, sure.
Second, you have advanced threat protection. This isn't just a basic spam filter. It uses complex behavioral heuristics to analyze links in real time. It catches and neutralizes a phishing attack before a tired paralegal accidentally clicks it at 2 a.m. But honestly, the most critical mechanism for the legal field is the information barrier.
Ah, right. You're referring to the digital ethical walls.
Yes. Information barriers allow you to systematically prevent departmental conflicts of interest at the database level. It's not just hiding a folder. When it's configured, you can program the environment so that the M&A team literally cannot communicate with the litigation team handling a related dispute.
It blocks them entirely.
Completely. If an M&A attorney types the litigator's name into the search bar, the system's graph pretends that litigator does not exist. It cuts the communication vector at the root. It brings the concept of the ethical wall directly into the code base of the firm.
Okay, I will certainly acknowledge the raw strength of the encryption, both in transit and at rest, and the necessity of multi-factor authentication, which, yeah, teams handle seamlessly. That is undisputed today. But I have to push back hard on the idea that information barriers are a flawless solution here.
Why? If the database literally prevents the interaction, where is the flaw?
Because the database requires human administrators to tell it what to do. The practical application of these tools requires flawless execution by the IT department.
Every system requires IT execution.
True, but an information barrier in Teams is not a physical wall. It is a highly complex series of digital tags, permissions, and Active Directory group policies. If a firm misconfigures an information barrier, let's say an administrator drags a lateral hire into the wrong user group during onboarding for even a single hour, the resulting exposure of sensitive files across the entire platform could instantly compromise a case.
Wait, aren't you just describing human error? Human error exists in every system, physical or digital. A partner leaving a sensitive brief on a conference room table for the wrong person to see is human error.
You cannot equate a misfiled paper document with an invisible cloud data bleed. Those are not in the same universe of risk.
Why not? A breach is a breach.
No, because scale matters. If I leave a brief on a table, one person walks by. The exposure is highly localized. If an information barrier fails in Teams, the entire firm's search index is compromised instantly.
That's a worst-case scenario.
It happens. The newly hired attorney types a generic keyword into the global search bar, and suddenly highly privileged documents from a conflicted case populate their screen. You've traded the localized risk of a physical mistake for the risk of an invisible, catastrophic data bleed that you might not even discover until months later.
But you will discover it, and that is precisely my point. In the physical world, if someone reads that brief on the table, you have zero proof it happened.
Unless you have a camera in the room, I suppose.
Right, which you don't. But Teams provides an immutable audit trail. If a barrier is misconfigured, the e-discovery tools built into the Microsoft 365 environment allow you to run forensic searches across all chats, document accesses, and logins.
Assuming you know to look for it.
But you have the capability. You can immediately identify exactly who saw what, down to the second. You have absolute forensic visibility for your firm's own compliance and liability management. And beyond just defensive compliance, we really have to look at how this platform actively empowers the life cycle of a case, specifically when we move into virtual advocacy.
Okay, you're talking about the shift to remote proceedings, the depositions, the mediations, all of that.
Exactly. Virtual hearings are simply a permanent fixture of the profession now. We aren't going back. Teams provides a remarkably professional-grade environment for these proceedings that consumer video apps just struggle to match.
In terms of stability, maybe?
And architecture. The architecture mirrors the physical world when we need it to. For instance, the breakout rooms feature. It allows an attorney to digitally step out with a client during a tense deposition for a private, encrypted consultation. It's exactly as you would step into a private conference room in a physical office.
Sure, breakout rooms are useful.
But Teams goes beyond just replicating physical space. With the Teams Premium tier, Microsoft introduced Intelligent Recap. This is an AI that automatically transcribes the meeting, generates comprehensive notes, and highlights task mentions.
Oh boy, here we go.
Hear me out. For a busy practice, this is a massive operational upgrade. It saves junior associates countless hours of manual transcription, allowing them to focus on actual legal analysis rather than just, acting as glorified stenographers.
We need to stop right there and look at the profound implications of what you just described, because this gets to the absolute heart of the risk.
You don't like saving time?
I don't like gambling with privilege. Deploying AI-powered automatic transcription in the middle of highly confidential strategy meetings or sensitive client depositions, that should terrify any risk management committee.
Why?
The data remains completely within the firm's encrypted tenant boundary. Microsoft explicitly states they are not reading or scraping that tenant data to train their wider public AI models. The confidentiality is entirely maintained.
It's not about Microsoft reading the data. It's about what the AI is actually creating inside your tenant. It is not merely recording audio. It is synthesizing information.
It's making a transcript and notes.
It is generating a brand new document, a summary of action items, strategic notes, and perceived conclusions. Have you fully considered the e-discovery implications of having a cloud-based AI automatically summarizing nuanced legal strategy?
I really don't follow your logic here. If a junior associate takes notes, those notes are also potentially discoverable. And frankly, junior associates misunderstand legal nuance all the time.
The difference is intent and autonomy. An associate is an agent of the firm making conscious choices about what to record and what to omit based on their legal training. The AI is an autonomous algorithm.
An algorithm you control.
Let's say you have a highly sensitive brainstorming session about settling a case. The AI misinterprets a hypothetical scenario as a concrete directive, auto-generates a summary, and saves it to the tenant.
Okay.
If that summary is later deemed discoverable because it might lack the explicit hallmarks of attorney work product, you now have a permanent, searchable record of a strategy your firm never actually intended to pursue.
That's quite the leap.
Is it? You are introducing an autonomous third party into the most privileged conversations a lawyer can have, and letting an algorithm decide what the most important takeaway was. That is an enormous structural risk that fundamentally alters the nature of privilege.
Well, that is an incredibly compelling way to frame the risk of synthesis. I'll give you that. However, I think that argument assumes the AI's output is treated as binding gospel rather than what it actually is, a draft tool.
A discoverable draft tool.
But the intelligent recap is a baseline efficiency mechanism. The attorney still holds the ultimate fiduciary duty to review, edit, and verify that record before it becomes a formalized document in the file. We shouldn't reject a powerful capability that gives attorneys their time back simply because it requires professional oversight.
It just adds another layer of review, taking away the time it supposedly saved.
I disagree, but let's move to the final piece of the digital architecture puzzle. If the AI is transcribing our virtual depositions and our documents are all locked in the same secure tenant, there is one massive vulnerability left: the cell phone in the attorney's pocket.
Meaning the actual physical hardware they use to make calls.
Exactly. If an attorney uses their personal cell phone to call a client because they are away from their desk, they bypass all of that secure infrastructure we just talked about. To truly have a digital headquarters, you have to address every single communication vector.
And I assume Teams Phone is your answer to this.
It is. Teams Phone finalizes this ecosystem by porting the firm's actual landlines directly into the cloud. The strategic value here is boundary management. Attorneys can place and receive office calls from their laptops or from the Teams app on their mobile devices.
So they use their cell phone, but through the app.
Yes, they can be standing in a courthouse hallway or working from a satellite office and call a client without ever revealing their personal cell phone number. It maintains that strict professional boundary while ensuring the call metadata is logged within the firm's secure environment. It's the final step in completely untethering the practice from physical geography.
Untethering from geography, sure, but tethering yourself entirely inescapably to Microsoft.
What do you mean?
Look at the architecture you have just described over the life cycle of this hypothetical case. The document management vault, the informal internal strategy chats, the external client video depositions, the AI-generated transcripts, the ethical walls, and now the firm's actual telephony.
It's centralized. It's a trap.
Moving the firm's entire operational apparatus into a single cloud ecosystem creates the ultimate single point of failure risk.
But consolidating IT vendors is a standard efficiency practice across every industry.
Not at this scale, and not with these stakes. If Azure has a regional routing issue, or if there is an authentication outage in Microsoft's 365, the firm doesn't just lose its email for an hour.
They have redundancies.
Outages happen. And when they do, the firm loses its case files, it loses its internal communication, it loses its ability to hold virtual hearings, and now, because of Teams Phone, it loses its literal phone lines, all at the exact same moment.
It's rare, though.
But catastrophic. The firm ceases to exist operationally until Microsoft fixes the issue. In the physical world, if the server crashed, you could still pick up a desk phone and call the court to explain. To mitigate the profound existential risk of crowd dependency, you inevitably require highly complex, heavily managed IT interventions and backups. Rather than simplifying the lawyer's workflow, you've simply shifted the complexity from physical hardware management to cloud infrastructure survival.
I view it as a matter of looking at where the greater, more probable risk lies. An intentional, well-configured Teams environment operates as an unmatched engine for firm agility, security, and responsiveness.
If you have the budget to configure it.
Yes, it consolidates your operations into a single ecosystem, but it consolidates them under an enterprise security umbrella that is vastly superior to the fragmented, patchworked systems of the past. When you leverage the seamless integration of your document management, the database-level security of information bearers, and the geographic freedom of modernized telephony, you are actively meeting your ethical duty of technological competence.
And my summary remains that while Teams clearly contains incredibly powerful features, viewing it as a turnkey legal headquarters dangerously underestimates the reality of how the software functions.
It's not turnkey, I never said it was.
But people treat it like it is. It requires heavy, constant, and unforgiving administrative protocols to keep it ethically sound. It is a generalist tool that demands strict behavioral modification from attorneys to prevent UI confusion and data spillage. And relying on it completely creates a single point of failure that no traditional law firm would have ever accepted in the physical world.
Well, I think despite our differing views on the architecture, we can certainly find convergence on one fundamental truth today. The era of consumer-grade messaging apps and unencrypted email is decisively over. Those are simply unacceptable vulnerabilities in the modern practice.
Completely agreed. We both recognize that the modern legal workflow demands an evolution. We cannot go back to the physical file room, and we certainly cannot survive on fragmented, insecure digital islands where every partner uses a different app. The shift to a unified system has to happen.
It really is a fascinating inflection point for the industry. Tools like Microsoft Teams are forcing the legal profession to actively define exactly where the software ends and where the practice of law begins. It is no longer just an IT question about storage space, it's a jurisprudential question about how we communicate.
Especially as we integrate autonomous tools like AI transcription deeper into the privileged relationship between attorney and client. That intersection of law and technology requires much deeper exploration, practically and structurally, in every single practice.
It really does. Because ultimately, we are still trying to figure out how to build those heavy oak doors and those secure locks in a digital space we cannot even see. We'll leave it to you, the listener, to judge which architectural blueprint best secures the future of your practice. Thank you for joining us on The Debate.